the Bar Council International Committee and the Criminal Bar Association wanted to arrange a seminar of this sort, and that's really how we come together to arrive at tonight. Now, as the chair of the meeting, I've got a few basic housekeeping announcements. The first is to request that all participants for the meeting both mute their microphones and switch off their cameras, so that everyone is present, but not via audio or visual means, because otherwise we're going to have too much of a jamboree. Secondly, as you may have seen, this session is being recorded and will be available to watch from the Bar Council website. And thirdly, and perhaps most importantly of all, any attendee can put forward a question to one or more of the panelists in the chat. Verbal questions aren't possible, I'm afraid. If people do that, we will look at the questions and try and perhaps consolidate them, and so that we can hear them all together and try and deal with it in the time we have available. Just by way of introduction, I can see someone's told me that I have a buzzing issue. I'm aware of that. I'm sorry. And I will mute my microphone as soon as I stop talking in a moment's time. We also have some rather more serious connection issues with Peter Haynes, and we'll perhaps come back to that. Could I just say this, that we thought it was opportune to have this meeting so that those of you who are new to this field of work can learn something about how to enter into it. We've been inspired to some extent by the success at the really top of the profession by two members of the English Bar / Judiciary, namely Judge Joanna Corner, Queen's Counsel, who, as you all know, recently topped the Association of State Parties poll and was overwhelmingly elected a judge of the International Criminal Court, and of course Karim Khan, QC, who similarly went through a rigorous election process, also topped the poll and is now the prosecutor of the court. So with two such inspiring figures from our own bar at the ICC, we thought it was a good time to have a meeting such as this. So tonight really it's a whistle-stop tour of how to get into this work. Frankly, it's not easy, but the speakers will tell you about their own personal experiences and how best to do it. Each will give you an individual story. Now, as far as I can see, I was going to start, in fact, with Peter, who was going to talk largely about defence work at the International Criminal Court, although he had some more general experience. I think he's still online. Perhaps, Peter, you confirm you're there?
Yes. I am.
Yes, good, that's great. So, Pete, just to let people who don't know Peter know about him, he is presently the president of the International Criminal Court Bar Association, the body that represents defence lawyers and victims lawyers at the ICC. He's a barrister with more than 30 years experience in both domestic and international courts. In addition, his work at the ICC has largely but not exclusively involved being lead counsel for Jean-Pierre Bamba between 2010 and 2018, securing an acquittal on appeal for his well-known client. He's also been the legal representative of victims at the Special Tribunal for Lebanon, and before that he had extensive experience at the ICTY, where he defended a man called Vinko Pandorovic, and I had the pleasure of co-defending with him in that trial for some 3 years. So I know him well, and I'd like to hand over to him. So Peter, take it away, please.
Thank you, and good afternoon, everybody. There was a staggering uptake in terms of interest in tonight's presentation, and it perhaps indicates a sea change in attitude at the British Bar towards international criminal work. It certainly was not so popular 20 years ago when I first went to The Hague, and indeed I sensed at that time that there was amongst, as it were, mainstream criminal practitioners a slightly sneering attitude towards those of us who left these shores and went abroad to ply our trade. Nowadays, it is very different. With the announcement of any new person being taken into detention in The Hague, there is a veritable international feeding frenzy amongst lawyers trying to obtain for themselves a new client, and it often brings out the worst in ethical behaviour amongst them, British barristers included, I don't hesitate to say. And of course, the focus is largely these days on the International Criminal Court, given the apparent reluctance of the United Nations to set up further ad hoc or hybrid tribunals, and the closure of the International Criminal Tribunal for the former Yugoslavia and Rwanda, and its morphing into the, as it were, residual mechanism following the completion of their work, not to mention the apparent collapse of the Special Tribunal for Lebanon, which the international community is no longer prepared to fund. And that's surprising, really, because those of you who've had a glance at the website of the ICC will realise that there are at the moment only 3 cases in trial there, comprising 4 accused. So there isn't a lot of work to be fought over, you might think. But there are, of course, at the International Criminal Court, which will be the focus of what I've got to say to you, 2 important things to bear in mind. And the first is there are very more phases of a case at the International Criminal Court than you as criminal practitioners in the United Kingdom would be familiar with, and more than the other international tribunals permit. There are now pre-investigative phases, there are pre-trial phases before you get anywhere near a trial, and those are likely to involve teams of lawyers throughout for a number of years. And the second thing to bear in mind about the International Criminal Court is that it does provoke a wider range of participation. In the pre-investigative phases and pre-trial phases, you're not just going to be having a prosecutor and a defendant, you're going to be lawyers representing groups of victims, lawyers representing other interested parties, lawyers representing states who are affected by the investigation and the trial, not to mention amici or amicus curiae. I'm sure Melissa could tell you more than this, but in the recent Myanmar and Palestine phases, there were upwards of 30 or 40 amicus who were involved in the decisions to proceed with an investigation. And each of them will have had a team of lawyers instructed to file and make representations on their behalf about what decision the court should take. So there is more work than meets the eye, notwithstanding the limited number of cases, and there are a number of avenues into it. And as David has said, the very recently formed International Criminal Court Bar Association embraces not just those who defend accused at the court, but those who represent the groups of victims, the amicus, and the states and the other interested parties. Now, I'm not going to bore you with the rules of qualification. You can look them up in the guidance for applying to become list counsel at the ICC. And if you're interested in working at the ICC, that's precisely what you should do. Put simply, you have to have competence in the relevant areas. You have to have 10 years relevant experience. You have to speak one of the languages of the tribunal, that's English or French, not both. And you have to have a record of high standing, which means that you, in conjunction with filling in the relevant application form, will have to provide your current practicing certificate, your current insurance certificate, a certificate of good standing from the Criminal Bar Association, and proof of your criminal record or lack thereof, as the case may be. Don't let it put you off if you're less than 10 years call, because you can become an assistant to counsel if you're 5 years call, And my experience at the International Criminal Court is that they're pretty lax about enforcing the rights of audience to counsel only, and they will happily allow those who are members of bars with less than the requisite degree of call, who are, as it were, part of a legal team as a consultant or as a legal assistant, to advocate in court. There are a number of areas about qualification which, on a personal level, I find wrong. Firstly, academics with no insurance, no code of conduct, and no practical experience in court are regularly admitted to the list of counsel. Secondly, and perhaps more significantly, once you have applied, there is very little check to see whether your practicing certificate and insurance certificate are up to date, or indeed whether you've been convicted of a criminal offence in the interim. And as president of the Bar Association, it's going to be part of my work, that it probably won't happen on my watch, to make sure that the Bar Association becomes the gatekeeper to the list of counsel at the ICC and regularly checks that people's credentials are up to the mark. How do you get into it? Well, I think the simple answer to that question is you have to get yourself into the conversation. And that may involve, as it would in any domestic line of work, you want to break into attending events, making yourself known, speaking, writing articles, and generally upping your Google juice. In my case, it was just a piece of luck. I was standing at my clerk's table, moaning about the fact that I was being sent again to Wolverhampton to prosecute a rapist who would doubtless be acquitted, or defend a Section 18 who would doubtless be convicted, when my clerk invited me to consider the possibility of going to The Hague, which I didn't know at that stage was even in Holland. And there it was, a fantastic piece of luck that changed my life for the next 20 years. Some work can come through more traditional channels. Obviously, where governments are involved in cases, they will have legal departments who are likely to come to your clerks in chambers, and it is always worth, when you know there is a situation going on, perhaps making it known to the embassy of a government that you are interested in and experienced in that sort of work. And it is often the case too that lawyers in the jurisdictions where accused are likely to be arrested, or where there are groups of victims affected by some atrocity, can find their way to chambers in the traditional way. The next important question, I imagine you have all got in your mind, is how much money do you make out of it? Where does it come from? Well, the ICC does have a legal aid fund, and legal aid is available both for accused who are arrested and in detention before the court upon proof of their being what's called indigent or qualifying for legal aid. And it's available for victims too. At the moment, it's only available for victims where counsel has been appointed by the court as victims' counsel, but there is a move to make legal aid available to victims' counsels at earlier stages, namely the investigative stages, because of course there are victims before there are accused, and there are a lot of people going out to work for them. Indeed, amongst my other interests, I've been represented victims in Myanmar and in Sri Lanka through various legal organizations who represent them. The aim of the ICC, of course, is to prosecute the most serious criminals for the most serious offences, and if that is the case, you might expect that some of them might pay you privately. And if that is the case and it works out, all well and good, but it is of course something to beware of. You are putting yourselves in the hand of somebody who can stop paying you, and the court will be most loath to let you out of the case just upon the basis that your client isn't paying you anymore. And not least, as I discovered in the case of Jean-Pierre Bemba, the International Criminal Court is quite adept, at the same time as being inept, at freezing people's assets. And what they did to Mr. Bemba was freeze all his assets and simply destroy them, and then proclaim that he was not indigent because he had lots of frozen assets. And so he was ineligible for legal aid. And the way that that was resolved was in the same way I think that most civil cases are resolved, where there are moreover injunctions or freezing orders, and portions of his assets to pay his lawyers on an interim basis. So that was a good working arrangement. You can get funded by NGOs and academic establishments if you're involved as an amicus or as a representative of a group of victims. But a lot of people are quite prepared to throw out a sprat to catch a mackerel, and there is a lot of pro bono work going on amongst those who represent amici and victims at the ICC. Let me just add the caveat emptor to all this. If you are interested in doing cases in international criminal law, it's likely to be a path that takes you on a very long journey. I have really done only 4 cases, and they have embraced the last 22 years. And Bemba itself was an experience a decade long. And it's very difficult, if not impossible, once you become embroiled in a trial in The Hague, to oversee or manage a domestic practice at the same time. And when you come back, you find that very much has changed. But that happened. I wouldn't change any of it for the world. It's been a magnificent experience. It's very different in many ways. You don't have instructing solicitors. You have to get involved in investigating cases yourself. And that is a great adventure, which I wouldn't have swapped for anything. I was supposed to speak for 10 minutes. I hope I wasn't too much more than that. Generally, it takes me 10 minutes to get the first joke out and introduce myself, but I'll give it up there. And if anybody's got any questions in the chat, I'll happily field them. Thank you very much, and thank you for listening to me.
Well, thank you, Peter. In fact, at the moment, there are no questions, but you've been almost 15 minutes that was allocated to you in total. So what I'm going to do is move on to Melissa, and then perhaps come back to you if there are questions of more general application. So our next speaker is Melissa Pack, who comes to this from a very different perspective. That though she's worked in this field since 2002, most, if not all, her work has been on the side of the prosecution. She was a prosecutor on the Milosevic case at the ICTY. Then she worked as a prosecutor at the Special Court for Sierra Leone, and then went back to the ICTY, where, though in fact our paths never crossed, Melissa and I have never met, but we worked on cases which have a very close common connection. And so when we were preparing for this meeting, had a great deal to speak about. She's presently employed, has been since 2015, as a prosecuting trial lawyer at the International Criminal Court, and remains an associate member of Temple Garden Chambers. So she's going to talk really about entering this work from a prosecution perspective. And I'm going to hand over to you, Melissa. Thank you.
Thanks very much, and great to be here, everyone, albeit virtually from The Hague. Peter's talked a lot about the opportunities at the International Criminal Court, so I'll just sketch a bit my various experiences in various tribunals and courts, including the International Criminal Court finally, even if the ICTR and ICTY now have become residual mechanisms, at least in the hope that those experiences will inspire you to think about work in this field. I started out practicing as a barrister at Chambers in London, and moved, as David said, to The Hague in 2002 to start working for the prosecutor's office there as a junior lawyer on the Milosevic case. And I must say that once I started in this field, I've never really wanted to do anything else. That is to say, I've never wanted to work in a field other than international criminal justice or something related to it. It's very rewarding work. I later moved from The Hague to Freetown in Sierra Leone, where I worked for the Special Court for Sierra Leone. Again, I worked in the Office of the Prosecutor. I expect you're aware that the Special Court was established by agreement between the UN and the government of Sierra Leone. So it had different origins to the ICTY and the ICTR, and was a hybrid international criminal tribunal based in country where the crimes took place. I mostly worked there on one of the cases which resulted in a conviction, the first conviction in international criminal law for use of child soldiers. And my work there was a real high point. To be working in country alongside the affected community where the crimes happened is an experience like no other in international criminal law, I think. It allows you to really immerse yourself in the country context, which is fascinating and also very important. I moved back to ICTY a couple of times after Sierra Leone. And finally, as David said, I returned to The Hague in 2013 to join the team prosecuting Radovan Karadzic. Before that, I had a brief return to practice at the bar. I did a master's, and I also worked for an NGO, and I set up an NGO as well. And I must say, I would never have thought to do those things had I not moved into international work. So essentially, this broad field of work has opened up a whole world of ideas and opportunities that I don't think I would have had I remained working at the bar in England. Back in The Hague for the Karadzic case, I worked on the Srebrenica component, and there had some crossover with David's work at the ICTY. And of course, that resulted in a genocide conviction for Mr. Karadzic. I joined the ICC in 2015, and I'm still there working for the Office of the Prosecutor. I suppose it took me a long time to get to The Hague, a lot of persistence. To work in the prosecutor's offices, you need to apply for advertised positions. You need to, it's really tough getting into the field. You have to be persistent. And as David said, you have to find, or Peter said, you have to find your entry point where you can. From my own quite varied experience, it's worth getting into any of the institutions or any part of the field just to get in. Any section or organ at my own court, for example, does work that is valuable and important, and it's worth just to get your entry point to get into any part of this field. It's all a very rewarding, very interesting work. So I can only say that keep an eye out for advertised positions. Perhaps consider boosting your academic credentials if you haven't done a master's in the field or any advanced academic qualifications in the field of international criminal law or international humanitarian law, then do that. Be prepared to complete multiple applications. And like I say, be persistent. It's well worth it. It's incredibly rewarding work. And as has happened to the others on this panel, you start and enter into the field and you never want to leave. I think that's all from me. If you have questions, then please do send them.
Well, Melissa, I'm going to ask you one question which isn't in the chat. There are some good questions. Could you very briefly explain opportunities in these courts, either at the registry or within chambers, and very briefly explain what that is, so that people know, because perhaps it's worth emphasising that the biggest difference between a prosecutor and a defence lawyer is the prosecutors at all these courts are employed by the courts. So at the ICTY, you were employed by the United Nations, whereas defence lawyers are freelance, self-employed, very much like we are in England and Wales.
That's right. Yes, there are employed positions in the court for the Office of the Prosecutor and also in chambers where there are positions for lawyers to work as legal officers, various different types of legal officers for judges, and they work for judges in the various chambers at the courts. And then there are also opportunities for lawyers in the registry, which is the sort of central administrative organ of the court. There are positions for lawyers within that organ as well, various types of positions in different capacities, not necessarily with the emphasis on international humanitarian law or international law, international criminal law as the central area of expertise. I mean, I can't say if or that there are any positions presently advertised. That's a totally different question. But those are the sort of range of different employed positions at least at the different courts and tribunals.
A question from Saba is about, are you permanently based in The Hague? If not, what's your split? So the answer is people, I'm going to answer that question, if I may, on your behalf. People who are employed by the court are expected to live in The Hague. That's right, isn't it?
Yes, yes. This is my home, and I've had to bring my family here, and this is where I live and work and have done for some time.
Peter, same question to you in terms of living for defence lawyers.
Yes, I mean, I've noted 5 questions that seem to have come my way, and I'll see if I can reel them off. No, a master's degree is not sufficient on its own. You would need to have the 5 years of experience in some field, probably maybe criminal legal aid work, criminal work at home, to qualify for the list of assistants to counsel, and 10 years to become counsel. The difference between being employed by the court and being defence counsel is quite profound, and one of the most significant differences, of course, and I don't mean to embarrass Melissa, is that United Nations or ICT staff are tax exempt. They do not pay income tax, whereas defence counsel currently do. I thought I made it plain. Once you get involved in a trial, you really cannot conduct any sort of domestic practice. Like Melissa, I own a property in The Hague. If I were as young as her and I had a young family, I would not be entitled to bring them across and put them into school and get the various allowances UN staff get. And I think David will talk a bit more like this. He has a young family. It's quite difficult. You do have to and fro. I was going home most weeks. Family were younger. Can you move from prosecution to defence? Yes, you can. There's no bar at all, except for conflict of interest, and quite a lot of people do. The impact of Brexit is profound. You now have to get your passport stamped travelling to and from the UK to The Hague, and you probably need to get a Dutch residence card to get around the current restrictions on your ability to live in the Netherlands. I have letters from the Dutch government informing me of the priority of my obligation to do that. Legal aid rates are up in the air. At the moment, there's a new legal aid policy being negotiated, but the current legal aid rate for lead counsel is about 10,000 a month. But what it will be in a year or two's time, it's hard to say. So I think that's all the questions that I fired my way. Sorry.
Peter, there's a question from Ben Knight at 1759, which I'd like both you and Melissa to answer. But basically, does speaking French fluently help at all? Melissa, you go first.
Yes, yes. I mean, this is you're doing cases in languages are really important. Obviously, you're doing cases involving multiple country contexts, and the official languages in any event of the court that I work for are French and English, and any additional language is in any event something that will be useful depending on the country context, obviously. But you can see the different situations in which the court is working. Yes.
Before I hand over to, thank you. Peter said he had nothing to add. I know that Peter's French is a lot better than mine, and I know that has assisted him in addition to his natural ability, because it's undoubtedly helpful to speak decent French, and fluent French is therefore going to be very helpful. One last question for you, Melissa. What's progression like at the ICC? Say one gets a job as an associate legal officer, can one progress swiftly? A very good question, really, about the bureaucracy of working for a big court.
Well, let's just say with my experience, I was very lucky coming up, and I think it's probably different for people nowadays, because I was able to move from tribunal to tribunal, and in so moving, I got, every time I went up another level. So it was in many ways easier, because if you were good at your job, you could just apply to yet another opportunity at another court and just go for it. And also that meant for a very fascinating and varied career. So otherwise, as in all of these institutions, the opportunities are limited by, whatever resources that are available. So, when there's an advertised position, there are opportunities, and when there are no advertised positions, then that's it. There isn't anything. As I say, it was easier, I think, for me, because I was able to move from institution to institution and kind of got up the ladder quite well through doing that.
Yes, thank you. Right, I'm going to move over to David Young, who really helped organise this event in his role as the CBA's Director of International Affairs. David is presently, I think, ostensibly based in The Hague as lead defence counsel for the Kosovo Special Chambers, which no doubt he'll tell you a bit about, where his client is indicted for war crimes and crimes against humanity. He spent, I know, a large number of years as the only UK lead defence counsel at the Special Tribunal for Lebanon, involving the assassination of Rafik Hariri, and his client, though not appearing at the trial, was acquitted of all the charges that he faced, and there was no prosecution appeal. He's also, as his CV reveals, got various other international interests, but he's really going to tell you about entry into some non-ICC tribunals and perhaps a bit more about life at the bar. David's a tenant at Red Lion Chambers. Thank you.
Thank you, David, and good evening, everyone. Yes, my journey, to be brief, started some 10 years ago, and French speaking was very important. And fortunately, because I was asked about taking a case at the Lebanon Tribunal, where the head of the defense office was French. So obviously it was a natural advantage. And in the Lebanon Tribunal, the three languages were English, French, and Arabic. And whilst I've tried to learn Arabic, I was fluent in French, and fortunately that helped a great deal. But English barristers are very sought after in The Hague. And it's important to say this because we have strong advocacy and adversarial skills. And a lot of the trials there are adversarial in nature. So a lot of the lawyers from the other countries come from civil law backgrounds and don't have expertise in cross-examination and in adversarial situations. So we have strong advantages. So English barristers are certainly very popular for some of the big cases. So when my journey started 2011, I was asked to lead in the Hariri assassination case. I was told it would be about 2 to 3 years, and it finished about 9 to 10 years later. So 2 to 3 years pre-trial, a trial of 4.5 years, and then 2 years waiting for the judgment in 2020. In between taking on the Kosovo case, which is only for the last 6 months, I was also engaged in another tribunal. I should say that at the Lebanon Tribunal, you have to adapt very quickly to a totally new way of working, as Melissa and Peter have said. So I ended up leading a team of some 10 lawyers and communications experts. So I had lawyers from all around the world, Arabic speaking, French speaking, English speaking. I had Chinese, American, Arabic, Lebanese, all sorts of different nationalities, and we put together a really strong team which worked really well together. But languages are critical, and so I'd implore people to really bear that in mind, and even take fast courses in learning languages if you identify a situation that you might be interested in. So, having spent some 9 years in Lebanon Tribunal, in 2018-19, I was asked to do, moving away from the defence, I was asked to take on an amicus role, as Peter mentioned. And these are interesting positions. And although I can't talk about it, I can say that I was then asked effectively not to defend, but to investigate a sensitive case. That's all, I think, all I can say. But it was with a view to a prosecution. And so you're not counsel, you're not a barrister, you're becoming effectively an investigator. You're a solicitor, an advocate, an investigator. You are everything, and you have to adapt quickly. And in these sorts of situations, you normally have small teams, but as Peter said, you can also have large teams. In relation to Kosovo, so in November last year, I was appointed as lead counsel, and now I lead a team of lawyers, again, mainly from Kosovo and Albania. And I have an English or New York qualified co-counsel, which you would describe as maybe as a junior counsel. And so I have a team of about 7 in that case. So the teams can be quite big. The previous one, there were 10 to 12 at one stage. So to tell you a bit about the Kosovo Tribunal, I think is important. I think that's principally what I've been asked to talk about. The Kosovo Tribunal is effectively the newest court in The Hague. Whereas some of the courts are dying, and the Lebanon Tribunal is effectively, as Peter said, finishing, and the other courts are short of work, the Kosovo Court is the new court. And it has a mandate over crimes against humanity, war crimes, dating back to the years 1998 and 2000. In this court, there are some 7 accused, comprising 3 different trials. So I'm in the principal one, co-defending with another English barrister, Ben Emerson. There are English barristers in other teams, but there are 7 different teams. So let me give you the bad news first. The bad news is because we're not in the EU, thanks to Brexit, British nationals cannot work as members of staff at the Kosovo Court. Only EU nationals can work there, or nationals from contributing third states such as Canada, US, Switzerland, Norway, or Turkey. So where are the opportunities? Well, the opportunities, if you're looking to try and get involved with the Kosovo specialist chambers, are principally on the defence side, because you cannot be staff there. So there's 2 ways to do it. In my view, the normal way, the historical way, is to apply for admission onto a list of counsel. So if you go onto their website, you'll see lots of useful information about being a defence counsel, or a junior counsel, or a co-counsel, that is, or a victims counsel. What I would say is this, that it's important to get on these lists, but it's not everything. Because Peter, and I'm sure Melissa would agree, I mean, for example, on the International Criminal Court list, there are probably over 600 names on the council. And I would say 99.999% of them rarely have any contact with the court. So they're on the list, but nothing ever happens. So I would suggest Plan B is probably a better course, which is, if you are seriously interested, you need to do your homework. You need to research what the court's about, what the case is about, find out who is involved in the different cases. So, for example, that's sometimes not easy to do. So it requires sometimes a bit of detective work, for example. But for example, in relation to the cases, if you go onto the website, you'll find that there is public documentation there, such as filings. We call them filings. And on the filings, you will see the names of the lawyers who are involved, or some of them, principally the lead lawyers. And that will help you. But I would recommend that if you are interested in a particular case or a particular counsel, if you don't know them, you try and contact them. You make a direct approach, a polite but direct approach, And this happens all the time in The Hague, and they're called basically expressions of interest. So you send a short email sending your CV, expressing your interest in working on the case. That's probably the best way to do it. I would also recommend, there is a defence office at the Kosovo Court. They don't keep what's called rosters, where you have lists of people who've successfully got on a roster, say, for example, for a case manager or legal associate or whatever. But I'm told by the head of the defence office yesterday that if you send your resume or CV there, they will hold them. And sometimes defence teams will reach out to the defence office for information about who may be available to take part in a team. But I would recommend thoroughly a direct approach to a team. And as Peter and Melissa said, there's not just one role. You don't see yourself as just as counsel or as barrister, because barristers can act in different roles, obviously depending on your seniority. But in a team, you'd have, apart from the counsel, you'd have consultants. You might have counsel who are acting qua consultants. You might have a case manager or two case managers or assistant case manager or a legal associate or two legal associates, part-time legal associate. You may have interns, and I normally run 2 to 3 interns all the time. And it gives them an opportunity to work their way into the system, into the hierarchy. So they learn the ropes, they learn the law, they learn the practice and procedure, and gives them a chance to develop into a more weighty position. Just so they're the kind of ways in which you can get involved with the Kosovo Court. I would also recommend this, that you do your homework in terms of the bar association. So there are 2 international bar associations. There's the one that Peter and I are members of, the ICCBA, the International Court one. But there's also the ADC, which is the Association of Defence Counsel, which deals, if you join as a member there, then you basically could, that applies to counsel in all the different international courts, not just one. And they have a members area. You can learn a lot. You really have to meet people, make connections, be very direct, network, attend the events, get super qualified. If you don't have any experience, do a diploma, do a master's. You have to do some work because it is very competitive. And when we all receive applications for team members, the level of qualification is often staggering. Not just 1 master's, but 2 masters for Leiden, Amsterdam, Oxford, Harvard, the lot. So I'd recommend you look at the 2 bar associations, and good luck. It's incredibly worthwhile. It's a really enjoyable, it's extraordinarily rewarding in many ways, and you learn a lot from the contact with many different cultures, people from different backgrounds, and you learn a lot about other legal cultures, which makes you, I think, a more rounded advocate. And that's all I'm going to say. I think I've probably run out of time. I should say that when you are counsel there, you have to remember that everything's televised. So it does teach you to speak clearly, speak slowly, because you are asking questions in English maybe, and there is simultaneous translation. But there's a lot of, you have to learn a lot when you go to The Hague, but you can pick it up very quickly because as English barristers, you will have a lot of advantages. So you play to your strengths.
So, David, I'm going to go back to the question that's just been asked. There are 1 or 2 others. This is from someone called Diana, who said that she's a UK prosecutor and barrister with 17 years, presently based overseas. You can probably see it. She's completed a master's in ICL, French. She wants to apply for a position at the OTP at the ICC. Is there anything else I should consider doing? So actually, I'm going to hand that over to Melissa, because obviously that's where Melissa is placed. So, Melissa, any practical advice you can give, please?
Well, the only thing I would say is obviously there are advertised positions from time to time at the court, and it's worth getting online and just checking out the landscape. I mean, I'm sure you've done that already, but you checked out the website and you've seen how the process works. and the need to, complete an application form. So you might think about making those preparatory steps early so that you can get yourself ready. If anything is ever advertised, then you can apply. Other than that, it's really just applying and applying again if you don't make it first time, and just being persistent. It honestly just requires persistence in the end, because it sounds like, there are some very skilled people with the range of qualifications, including academic, experiential, language. So you really just have to keep on making those applications.
David, a question really for you, based on a question that Marie-Anne has asked in the chat, but perhaps just expanding it a little bit. When I did this work, I really stopped doing it 10 years ago, we on the teams that I was in tended to have young barristers, often English barristers, assisting us with specific areas of international criminal law, because the people on the teams I was in, frankly, were not expert in that. We'd largely been recruited, as you say, as adversarial advocates, because the case required at least 2, if not more, experienced advocates, and we were not very expert in ICL itself. And so we would recruit people who would be very involved in writing the briefs. What sort of opportunity exists these days for those who are perhaps slightly academically minded to help write briefs for counsel, and then perhaps move on to do the advocacy some years later?
Yes, well, that's a good question. There are plenty of opportunities, because a lot of the work, as we all know, in ICL is in pleadings, what we call filings. And there are filings all the time. I suppose the nearest we have is a skeleton argument, but there are filings and filings where basically all the different parties draft legal arguments, and there is an application, there's a response, there's a reply, there's a decision, there's an appeal. It's quite a system. So if you're a good writer, and you can pick up the practice and procedure of the International Criminal Courts quite quickly, and most of the procedures are quite similar, because often when they start a new court, they do a cut and paste job from the rules and regulations in another court. So you can pick up the procedure very quickly, but what I do is certainly surround myself with experts who have different strengths. So we all have different skill sets. Some are strong advocates, some are strong writers, and some barristers will start out in a team as a legal assistant, and then become a legal officer, and they'll be dealing with small filings, and then they'll be dealing with a lot of writing work. What I tried to do with my team was to develop them. So I took on a young barrister from my old chambers, and who is exceptional, and she's doing brilliantly. And I took her on as a legal assistant, and then I promoted her to senior legal assistant. Then I promoted her when there was an opportunity to be a co-counsel. So I made her effectively a second junior counsel. Then I tried to help develop her skills by offering her advocacy to do some oral arguments, and that's what I've done with my teams. I've tried to bring them in and develop their careers, put them on training courses. But there's plenty of positions where, as a barrister, even if you can't get a speaking part, you can start off in a non-speaking part and then develop into a speaking role. And for example, even if and it's difficult to secure a lead counsel or a co-counsel role, but if you secure a role as a legal officer or a consultant, even as a consultant, you can still get rights of audience in most of the international courts if you're a barrister with the requisite court experience. And as Peter said, even some academics are allowed advocacy rights. So they will certainly, if you have the requisite years experience as an English barrister, I think you're likely to get the right to speak in court as a consultant. So there's lots of different opportunities, and these are big teams. So don't just worry about the fact you can't secure initially a position as counsel.
Now, Marcus has asked a question about Amicus Work at the ICC, And I'm aware that there's quite a lot of that work because, as we've just heard from Peter, in some of the situations and cases, there have been a great number of submissions from lots of different interested parties. I think that work is largely written work, but how does one get into that? I personally don't know. Peter, yes, can you help? Thank you.
Peter?
Yeah, I mean, I think it's probably best if I give an illustration. In the Bemba appeal, we used two professors of law, one of whom had a lot to do with the drafting of the Rome Statute itself, the other of whom was a fantastic military lawyer who had been a special forces soldier in the US forces, and they knew a great deal about how and why sections of the statute were drafted, and in the second case, how the laws of war operated in combat situations, and they were very good. And because it's sort of, you scratch my back, I'll scratch yours, because I instructed them to act in the Bemba case, whenever an issue occurs at the ICC in relation primarily to jurisdictional things, they always have a dog in the fight. And what tends to happen is that various organizations, universities, NGOs will have a view as to whether, for example, the Palestinian situation should be investigated, notwithstanding, which is all, as you probably know, based around whether Palestine is a state. There will be a large number of people who have views on both sides of the coin. Now, my own personal opinion is that the ICC accept far too many amicus briefs, but they do, and universities will develop funds to build legal teams. And so you tend to get into that by being associated with an organization that has a point to make about a jurisdictional issue at the court. And those issues are very often binary, but the court will accept, 10, 15 views on either side of it. And if you're lucky enough, or you have the connection with somebody, as indeed I have, they will come and say to you, okay, will you help us draft an amicus brief on the Palestine issue, or on the Myanmar issue, or on the Afghanistan issue? So that's really how you get into it. It may well be your alma mater. It may well be a professor where you're at university has a view about an issue at the ICC, and you say to him, I'll help you with that. So that's how that happens. And the other huge grouping of people involved in that would be the victims groups. And the victims groups you tend to get involved with, again, through organizations that help victims who want to have a lawyer on their board or on their note paper. So that's how it comes about. And it's a good way in. And I can say this, although my heart is in defence work, I found victims work very rewarding too. Particularly that I've met many people, many Rohingya from Myanmar, and been involved in advising them, and that's another aspect we haven't really talked about it to any great deal today, but it's another way into work at the ICC. Thank you.
I'm going to ask one final question, which I think is the last question in the chat, from Eleanor, and it's really very much a question which sums up what we were trying to achieve this evening in trying to guide and help people. You've each talked about it in passing in your very helpful presentations, but perhaps each of you would say a short word really about someone absolutely starting off at the bar who is passionate about this work and wants to get involved in it. What would be your top tips? Peter. Sorry, I said Peter. I beg your pardon.
Get on the list, whichever list you are qualified to be on. be prepared to go and spend some time with a legal team in The Hague as an intern for 6 months or so. That would be my advice to anybody. There is one thing I don't think anybody said, and that is that it is a massive advantage in obtaining an entry to this work to be in The Hague. If you are in The Hague and you are available, you are at the head of the queue. And if you are qualified as counsel and you're there as an intern, an opportunity, as David has just amplified in the case, I guess, of Sarah that you were talking about, you can climb up the ladder. And there have been many people in my teams over the years who have begun as interns and have literally ended up either as P5s within an organisation or as counsel. So,
thank you, Melissa.
I would make sure that you're following this field online. There's huge talk in the blogosphere and on Twitter, lots of academics who comment on this work and will forward and advertise posts that are available in the range of areas of practice within this field. And I would just keep an eye out for any opportunity. It need not necessarily be at one of the courts for the defense, for anything. It can just be something completely different that you never thought of doing. Go and work for an NGO, anything, to get into this field and to gather some experience in the broad field of international criminal law and international humanitarian law. So I would just keep an eye out for any sort of opportunity and just go for it.
David?
Yes, I agree with both Peter and Melissa. I would certainly say go to The Hague, try and get an internship, learn languages, do a diploma in ICL if you haven't got any ICL, do a diploma, do a master's. And one thing we haven't mentioned is that the powers that be are clearly trying to limit the number of international criminal courts in The Hague. And for example, at the IBA conference a couple of years ago, there was a question, is the future of international criminal law national? And that's true. They all agreed it was. So there will be a lot of international tribunals around the world in the future. And they will be not so much in The Hague, but they'll be in different areas all around the world. So keep out, read the news, follow events, and react very quickly. If you see a situation, try and make a direct connection with somebody that may be involved. So do some detective work and learn a language. Here's my tip, Arabic.
Thank you very much. In fact, that to some extent, your comment there, David, answers Will Burns' question, which is slightly beyond the scope of this particular presentation tonight, I think. But in fact, it really allows me, works me easily and well into my concluding remarks, because I was going to recommend that anyone remotely interested in this work read the interview with Karim Khan, headed Laws of Humanity, in this month's Council magazine. There's a splendid picture of Karim, I think probably in Iraq, on the front page. There's a fuller version of that interview, which one can find online. And in it, Karim says exactly what you've just said, David. So I would really recommend that. First of all, it's an inspiring story as how Karim, in not a very long period of time, about 20 years, having got into this work, has risen to the very top, undoubtedly the top job in international criminal law. But secondly, he gives some tips to people as to how one can progress and get on and enjoy this world. So I certainly recommend that article. I hope this evening has been reasonably pithy and short. We've deliberately kept it to an hour. I certainly would encourage anyone remotely interested to do exactly what was said by all the speakers, namely join the lists. In particular the ICC list if you're eligible. It can take a bit of time, it doesn't cost any money, but equally if you're eligible, and most barristers of sufficient numbers of years call will be eligible, it's worth getting on to the list. And so finally, before I hand over for a last word, I want to thank all the speakers for their interesting cogent and eloquent presentations. I also want to thank the staff of the Bar Council International Committee for their technical and other assistance. And in that respect, I'm going to hand finally over to Christian Viscosian, who is the Bar Council International Committee's man at the Bar Council. He runs the committee, in effect, on behalf of all of us, has done the job for a number of years, to make some concluding remarks. So thank you for listening to me.
Yes, thank you very much, David. And I wanted to spare you the embarrassment to thank yourself. So I am very pleased to thank you, David, for chairing tonight's event, as well as thanking also on behalf of the Bar Council all the speakers. Yeah, my name is Christian Viscosian. I'm head of international policy at the Bar Council, and I'm overall responsible for the international work of the Bar Council. And I'm really delighted that we had such a massive interest in tonight's event. We had over 250 registrations. Unfortunately, the busy practice at the bar didn't allow all of these colleagues to join, but the recording will be made available in the coming days on the Bar Council's YouTube channel, and there will be a link on the Bar Council's website as soon as my excellent colleague Claudia Domanska, whose name you will have seen in the chat, has been able to sort all this out with the technical colleagues. And I would very much also like to invite you to make a note in your diary for the second event in this series, which we're planning to hold on the 9th of September, all being well at the same time. And David Young from the Criminal Bar Association is preparing a very interesting panel for that occasion to look at the opportunities that are emerging now beyond the international tribunals, unusual and new avenues to practice international criminal law, and we very much look forward to seeing many of you then. And yes, maybe finally to also again thank the Criminal Bar Associations and David Young, who's the international director, for the collaboration with the Bar Council on this event. And we really look forward to going on to promote this area of practice in the future, both of our organizations. So thank you very much, everybody, and have a wonderful rest of the evening. Bye-bye.